Secretary for information on today's agenda.
Each commissioner has independently reviewed the minutes of the open meeting of Thursday, September 2nd, 2021, and each has informed me there's no need to discuss those minutes.
Move we approve the minutes of Thursday, September 2nd, 2021.
Second.
All in favor?
Aye. Each commissioner has independently reviewed the agenda, and each has informed me there's no need to discuss the notices associated with agenda items 2 through 22, or the suggested minute associated with agenda item 23, closing docket 9300 SI 124 without prejudice.
Move we approve the notices of investigation associated with agenda items 2 through 11.
Second.
All in favor? Aye. I move we approve the notices of proceeding associated with agenda items 12 through 22.
Second.
All in favor? Aye.
Aye.
Agenda item 23, docket 9300, SI 124. I move that we close the complaint against Lake Pepin against the Village of Pepin concerning sewer rates.
Second.
All in favor? Aye. Aye. Okay, that brings us to agenda item 24, which is docket 6630-CC-227569. This is a request that was filed by a customer, Mr. Tim Ballering, for formal review of his complaint against Wisconsin Electric Power Company. He's disputing the transfer of arrears between the rental dwellings that he owns and his business office account. He's had a pretty long history with the company in terms of how all of his rental properties are handled. He filed some information in response to the commission memo in this case. And as I was reading through the information, I think he's bringing in some new information, but he also brought up some information that was talked about in the memo and was looked at during staff's review of his complaint. And I think some of that needs to be looked into. So initially, I was going to deny the complaint, but I think we need a little more information. I'll also say what was concerning to me is that staff uncovered this owner agreement, which appears to conflict with the 15-day notice requirement in the law. And it would have been helpful to hear back from the utility to find out what's going on here. He's got a lot of properties, and I think that the business center at the utility has worked with him for a number of years. But I have some questions, and so I reached out to staff, and I asked a couple of questions, and then in return, staff came back with a couple of questions. And so my proposal is to actually stay this matter and just remand it back to staff. Because I'm not quite prepared to go down the route of opening a formal complaint, but I do think we need more information. In particular, I think we need information about the customer change forms. So he's telling us that he sent these forms to the utility, but then they weren't processed. So I would like to hear more about that. I would like to hear about the records related to some of the specific addresses in his complaint. And I can either show you guys this list that I have, or I can go through it, but it really is the result of the information that he brought in, and I'm not suggesting that we open it up to, because he threw in some new issues, and I'm not suggesting that we go down that road, but he did raise some legitimate issues that I think we need information on. In particular, I think we need more information on the 2466 South 10th Street property, the 1222B South 17th Street property, and the 1543 South 10th Street property. So he is disputing that his staff actually started service at those addresses. So I think we need more information. Again, it also would have been helpful to hear back from the utility. I'd like to know the length of time that it took the utility to respond to his initial complaint and whether the accounting of his disputed bills is correct. So as I'm looking through all of the information that he provided, all of the information that staff has, some of the amounts don't appear to reconcile. So I think we need to know whether or not the accounting of those disputed bills is correct. I think I'd also like copies of the arrears transfer notices that were sent to his company prior to the disputed transfer of arrears. We don't have that information. And then finally, the 15-day requirement was just kind of left open-ended. So I'd like staff to just go back, work with the utility, and ensure that their owner agreements and their practices as it relates to owner billing agreements are consistent with the 15-day notice requirement. And if staff has any issues, then they can come back to us. So those would be the things that I would seek. And so it's a new alternative, which would just stay this complaint and remand it back to staff to gather that additional information. Then they can come up with an updated memo, and we can talk about it
Okay.
on a later stage. So that's where I am. Commissioner Noel?
Thanks. Either an updated memo or hopefully an updated resolution might be good. Initially I was at dismissing his, I'm not sure if his response helped or actually pushed me more to dismiss because I was a little confused too by what he filed. He did bring a lot of new information in, and I'm glad you're not at reopening or having a hearing because I'm afraid that would expand into something that's well beyond what this initial complaint was about. So, I think there was a lack of information on both sides here, both from him and from the utility. Like if he said, those copies of the forms, that, he's obviously a landlord that's got many properties. He's been doing this for a long time. Where are his copies of any of these things as well? I had a problem with that going back and forth. So, and then if there is a problem with the utilities notice requirement, it seems to me we'd be hearing from a lot more landlords and multi-unit property owners. So I'm tending to believe that things are fine, and maybe just getting a little information that clears it up would be helpful. So, but there is clearly a long history between this customer and We Energies, and sounds like they need to maybe keep a better track of communication. So I can agree with your approach. And the one thing I thought maybe we can get more information on, he does dispute that his staff agreed to reconnect at those 3 properties. I don't know how that will, I don't know if we'll actually be able to do that either way, but that's where I was struggling with even sending it back for information, because there may be nothing that exists that documents that at all. And it'll be a he said, she said situation. But I think I can accept let's just let's send it back and get some more information, and hopefully, and I'm fine with all the information you suggested, get some resolution or at least have it expressed again.
Okay, great. Commissioner Heber?
Yeah, I came into this at alternative 1. I think that you laid out a number of questions, Chair, that I had remaining as I looked at this, and so I will join you at your position from an administrative point, how we get those answers, because I think that's where I was at. Is I think there's unanswered questions here, and we need to figure out what those are before we can resolve this. I agree. I think staff, good job of reconciling that form and understanding that there was a disagreement with the way it should have been written with the law that we have. So I too would like closure on that. So I'm going to join you at your position. Thank you.
All right.
Okay, then I will move in.
You don't need to, we just lay it over.
Or just lay it over. I was going to remand. Okay.
Yep.
Well, that's even better.
All right. Okay. So now we move on to agenda item 25, which is docket 9807-CE-100. And Commissioner Huebner is going to lead the discussion of record for this case.
Great, thank you very much. This is a docket for Springfield Solar Farm, LLC. It's a subsidiary of National Grid Renewables. They have proposed a 100 megawatt alternating current solar photovoltaic generating facility to be located on approximately 935 acres in Dallas County. The interveners of this proceeding included the town of Lomira, the village of Brownsville, the village of Lomira, and Renew, Wisconsin. A party hearing was held virtually on June 15th, and public hearings were held, 2 public hearings at 1 and 6 p.m. on June 16th, also virtually. We received many public comments during the development of the environmental assessment, and again, there was a public comment period from May 7th through June 22nd. We received over 130 written public comments during that period, and 18 individuals participated in the public hearing as well. The specific application in front of us today is for a merchant generating plant. Thus, under the CPCN statute, many requirements apply, but items related to need and economic factors are not part of our decision today. Alliant Energy, this is in the record, Alliant Energy has proposed to acquire this project in a separate docket where the economics and need for that utility will be evaluated, among many other factors. For this proposal, our job is to consider whether the design and location is in the public interest, considering alternative locations, individual hardships, safety, reliability, and environmental factors. In addition, a key issue in this docket raised by the village of Lomira is whether or not the proposed facility will not unreasonably interfere with the orderly land use and development plans for the area involved. In previous dockets we've had, I've outlined some of my thoughts on solar development, and a few of those I'll just repeat here. First, we have an energy priorities law passed by our state legislature, of which solar energy is included among the second highest priority on the list. Our state's electric generation mix is shifting. It's reducing our need to import fuel and pay money to other states, and instead harnessing an energy source we have here in the state, and the Wisconsin Land and Liberty Coalition pointed that out in their public comment. These types of projects, after they're built, don't produce any air pollution. They don't use any water. They don't have any water pollution as compared to other ways of generating electricity that we have in Wisconsin today. It doesn't require any new fuels to be routinely brought to the site. And as we have in state law, there will be economic benefits for the local and state economy. Approximately $400,000 annually will be provided to the local governments that host the project. With all that said, this project for me presented some new and to me at least more challenging aspects. There was a lot of citizen opposition and not a lot of citizen support. And there can be a lot of reasons for that. We do see that sometimes in dockets. But this is the first one on solar that we've seen such a difference, I guess, between how many opposed and how many support from the public comments. I want to reiterate that, solar developers operating in the state, they really need to work with the community. They need to answer people's questions. There was a lot of people that indicated they felt their questions weren't answered. I don't know if that was timing. I don't know. But it was, I don't think it was our best example yet of what we've seen of the developers working with communities. A couple things I noted that are different appears to me that the landowners are selling the land and not leasing the land. So I don't know if there's sort of a, not a long-term engagement of the landowners. It doesn't look like there's good neighbor payments offered. And then, as I mentioned, there's 2 other issues that are new to these dockets. First is there's an interstate pipeline running through the project. I thought our staff, Alex Kirschling, did an excellent job of explaining the issues related to that, and I thought the applicant's expert witness was also very good. I know there was a public commenter that did extensive research as well on this issue, so that was new. And then finally, the Village of Lomira's primary issue related to the development of these properties, the Elsinger, and I'm going to call it Kazimierczak properties. Some of that's in the village, 200 acres is in the town, but it just presented new issues. Just kind of a note, I guess, to developers again on the public comments, but you know, the cutoff for this is 100 megawatts. Below that, you've got to get local approval. So when you come to us with 100 megawatts, right at the cusp, you know, it just becomes a really challenging. I mean, I'm like grinding through this because you know we have authority, but we have to use that judiciously. Of what is the state doing compared to local governments? We also have to be judicious about what is the state doing for local landowners that are willingly offering to sell their land. So to me, those haven't been in tension in the past, but they are a little bit in this one, where you got a private landowner willing to sell, but a local government saying, well, we don't want you to sell. So it's just a little different. And when you come with, like I said, right at that cusp, it just was a more challenging review in my perspective. So I'm going to leave it there and see if either of my colleagues had other opening remarks.
Thanks, Commissioner Hiegner. That's a good synopsis. The thing that ran through my mind was the honeymoon's over. And I think we saw that in wind development as well. The first couple of projects, you know, went off very smoothly. And I think that this represents, I mean, I agree with you. We've not seen this level of opposition. And the tension between the local zoning authority, and you know, so much emphasis placed on that 2005 comprehensive plan. And so again, it behooves, just to reiterate, it behooves developers who are coming here to really work with the local landowners, because you're exactly right. They're right at the 100 megawatt mark. This one was a tough one for me. Because you said it perfectly. We have to use the power that we have to permit judiciously. And this one was a tough one. So I'm interested to see where the...
Yep.
Well, I'm heartened to hear you guys struggled with this as well, because more than any of them, this is the one I struggled with the most. For a lot of the reasons you stated. And there's a reason why they're right at 100. I think that became clear throughout why it came to us. But it also, you know, it's the cumulative effect, which I talk about every single time. It's the rush to replace high-density, reliable, dispatchable power with intermittent, low-density power that's going to consume a lot of land. And, you know, at the rate at which we're retiring the coal and the difficulty in putting natural gas in, the amount of, this is just going to get worse, right? These fights are going to get harder, and the placement of these is going to get harder, because I think people are finally realizing that, you know, we can't, it's not a megawatt per megawatt replacement. More than any other, you know, and the public comments were so heartfelt, and many people have said, please come visit the area. I'm familiar with that area. And I know they are very sincere in their statements, but I never saw so many in a comments where it says, I'm not against solar, but I just don't want it here. Well, where are we going to put it? Mm-hmm. Some people said, let's put it out in the desert. Let's put it out west. Well, guess what? We were doing that, and we know the difficulties in setting transmission lines to bring that power in. So these are not easy decisions at all, because you struggle with the property rights and what a local land use wants. But you guys said it best. I think the entities coming in that are developing these must work very closely for a long time with the localities to figure out what's going on. But also, municipalities, if they need to update their plan,
Right.
We can't go back and fix something for them. So if they want to, maybe this is a wake-up call to them and say, what's on our books? What do our plans look like? What do our ordinances or comprehensive plans allow? What does our zoning allow? Because we have limited authority to make changes. We can't change what locals want. I don't ever want to do that. Their zoning. So I'll just leave it at that, and let's walk through.
Yeah.
Here we go.
Yeah, and I think if any of us want to take a break, I know in the past ones we've been able to move through, but if there's certain issues, certainly let's take a break if we need to.
Okay.
There's a number of items that are listed as uncontested. Do either of you have any reason to discuss those today? No. Okay. That moves us ahead to issue 3, which is one of the key issues in this case. If approved, would the proposed project comply with Wisconsin Stats 196.491 3D6 and not unreasonably interfere with the orderly land use and development plans for the area involved? And just again, to tee this up, obviously it's very fresh in our minds reading this record, but about 65 acres of this is in the village of Lomira, and then directly north of that is 200 acres that today is in the town of Lomira. In the comprehensive plan that was completed in 2005, those areas were identified by the village comprehensive plan as suitable for industrial development. Sort of skip a parcel north and then you're at Quad Graphics, a really large industrial facility, one of the biggest facilities in the state, in fact. So this area does have industrial development in it. This was a really hard one for me. I think where I've ultimately landed, and I'm open to discussion with my colleagues, is you've got this sort of triangle. You've got the state authority and our view of weighing this evidence. You've got the village's plans, but the town of Lomira has signed the joint development agreement, right? And so they are essentially, I'm not saying they're approved, but the village hasn't, but the town and the county has. And then you've got this private landowner. And as I said, for me, I want to use our light touch. We certainly don't want to preclude anybody's private property rights voluntarily. We also don't want to override these, village plans. But in this particular case, that village plan is outdated. I think that the applicant's witness talking about the zoning and the applicability of the zoning as the implementation of the plan. Again, to me, the weight of the evidence cited on that those areas are suitable for development, and that although the village had conceptually wanted to use that, and that there's attributes to that site from an industrial development perspective, the record, and this went back to emails that were in exhibits of, do you have a lead? The lead went cold. Where is this at? And it's like, we have this solar now. We have this solar development on the table now. We have perspective, but unsure if that's going to materialize for industrial use. So again, this was not an easy one for me at all, as I think you can tell, but I landed at alternative 1, that this does comply and would not unreasonably interfere with the land use and development plans for the area.
Yeah, and I guess for me, it was close as well. And where I landed was where Commissioner Nowak stated in your opening comments, we can't go back and change that plan. The plan is from 2005. And we can't say, sure, maybe you'll get an industrial facility there in the next 10 years. That's not our role.
Right.
Ultimately, I landed at alternative 1. But this one's a close one.
Mm-hmm.
I ultimately ended at alt 1.
this was a hard one for me all week long. I was back and forth because to me, it's a sign of things to come. And it worries me that, and which is why last week when we talked about the roadmap, I wish that we could almost pause things right now and then take a look and what's this really going to take? Is that where we want to go? Because I know that we're moving towards a generation shift, but I just don't want an overcorrection that happens and also interferes with the property in this state at the same time.
Mm-hmm.
But you have to take a look at what does the law say,
Mm-hmm.
what does the plans of the village and town say. I think there's a couple things, and you guys talked about it. The village comprehensive plan, it's out of date. And their zoning ordinance, which is more recent, it is consistent with a conditional use under their zoning that I found credible. It's also consistent with the Dodge County plan. To me, how did you pronounce Kazmierczak? I apologize to him. I wish I knew how to pronounce his last name.
I think you did a good job, to me.
His property, that the village is trying to tell that individual how he can use and sell his property. That one I just did not buy at all. They did not cite legal support for that. There's no intergovernmental agreement they had with him. Yes, there can be annexation, but they didn't produce any evidence that it was imminent. He even himself, he's willing to sell it. And that is a tenant of, your personal property. You can do what you want with your property, and if it's consistent. So he, ultimately he can do that. And they proposed to, they said, well, we extended sewer and we're doing all that. Well, that's a risk they took. They obviously wanted something in here, and it seems like they're not happy that it happened to be a solar developer that came in. It used to be too that a lot, the community solar, we all wanted it right there. They wanted to be able to see it, right? Now it's like, well, we want it, but we don't want to see it. So I'm getting all this whiplash back and forth that's starting to control, we don't want, So ultimately, I came down with where you guys are at, that is there interference? Yes. Is it unreasonable? No.
Mm-hmm.
And so I join you at that.
Yeah, I appreciated Mr. Kazmierczak submitting rebuttal testimony to directly, on the record, state the status.
Right.
And just to repeat what he did say in testimony, has the village of Lomira come to you with an offer to purchase the property? No.
Right.
Has the village ever asked you to annex the property? No. I think that there was steps taken, but there were still many steps to go before there's an eminent industrial customer coming to that, and we're just sort of the bird in the hand versus two in the bush a little bit.
That's right.
I don't know if that's a good analogy, but okay. So issue 4 was related to brownfield sites, and that was uncontested, that there was not a sufficient brownfield site that could house this facility. Issue 5 is the design and location of the proposed project in the public interest, considering the siting criteria of WISTATS 196.491 3D3, or should the commission modify the proposed siting areas? So Springfield Solar has proposed the project, the proposed areas, and the proposed arrays, as well as sufficient alternate arrays that could house up to 25 megawatts of facilities. I'll just kind of go through again. I thought some of the public comments, all of them heartfelt, all of them certainly emotional, but in some ways and I think on the same page, but it just was a little interesting that, both of them are saying, or residents from both villages said, this will close off growth opportunities for either new housing or new business. There were residents of both that also said, preserve the farmland, and we want to keep the farmland. And I think that it's just interesting. Those are in conflict as well, right? I think another issue, we talked about the village issue. The other different issue in this that I alluded to in my opening comments was related to the presence of a gas pipeline, and actually two. One, a high-pressure pipeline owned and operated by Guardian. This is an interstate pipeline. The regulatory authority for that lies with the federal government, not here at the PSC. There's another pipeline on the north side of that project that runs east to west over to Quad. That's an Alliant line, and so we do have authority over that as far as safety goes. And obviously Alliant is a regulated utility here in the state. I spent a considerable amount of time on the phone with Alex yesterday, reviewing his testimony and the record. There was a lot of comments brought up about the potential for stray voltage and essentially the voltage getting into the ground and increasing the corrosion of that pipeline and weakening it to the point where it could present a danger. Just my view is that based on the record we have, both our staff expert, who's an engineer in this field, Alex Kirschling, as well as, this is another name that's a little harder to pronounce, but the applicant's rebuttal from Filch, a Stantec employee who, this is his line of business and his experience. Both of them concluded, and we will have some potential conditions related later to this, that the setbacks were appropriate, that the risk was very low related to stray voltage or other issues. One of the commenters did an excellent job of researching this topic and wrote an excellent public comment and expressing her concerns that the setback should be farther. And with all due respect to her wonderful research, I think this is an issue, again, that may come up again. It probably deserves more attention, but based on the expert witnesses we have here, I didn't see any other setback distance that would be different than what has been prescribed here, that this setback wasn't appropriate, and as this issue says, in the public interest. So those were the issues for me. The third one that came up in public comments, again, not really in the record at all, except for public comments, was that typically, or that sometimes, at least it has happened, according to some local residents, that the rail line that goes through will throw sparks. And if it's a particularly dry situation, that, the grass near that railway can start on fire. So I don't have an order point on that, but I think the applicant or eventual owner needs to look into that and make sure that their setback is appropriate based on local conditions for that. With that said, I am at alternative one. I didn't find that any particular array or portion of array needs to be moved. I think that the primary array is superior to the alternatives because there's less of an impact or encroachment on the residential areas, that the alternatives get quite close to the Brownsville and residential areas that have been developed, but ultimately I did not find that they were, that they couldn't be built on. So I was at alternative one.
I agree with you. I thought in this particular case that they met the burden on this statute, so I was at alternative one.
Yeah, I think this is much clearer, the weight of the evidence on this one. The expert testimony, there was that one commenter. She did do a lot of research, but I don't know her background. I don't know what exactly, she was looking at. The weight of the evidence regarding the gas pipeline, these do coexist. I think this is kind of, again, the first one that was come to awareness about it. And there are mitigation steps that we can talk about in a bit. There was also a discussion, I don't know if we should have talked about it last time too, like moving, that, whether it was the 265 acres between the Elsinger and the Kismerick, how did we say that, property?
Right.
There was no engineering evidence to support that you could just take that chunk out and move it to the alternative site and you'd still have 100 megawatts. From the applicant's perspective, you'd be 17 short, and then we get into a whole legal morass of is that in our
Right.
So that did not carry any weight with me either. So I just wanted to acknowledge that I did look at that and considered it, but the evidence was clearly more supportive for the applicant on that. So I join you that I think all the primary sites are.
Okay. Issue 6 is what general conditions similar to those that have been included in prior electric construction orders should be attached to construction of the proposed project to meet the requirements of commission approval. There are potential conditions A through M. Some of them have, A through Q, on to the next page. These are things that we have continued to find to be needed conditions and in the public interest. Springfield Solar had one modification related to condition 6F related to the Alliant Energy ownership. I was fine with that language. The Village of Elmira had a concern basically requiring the permit and the project to comply with all federal and state laws at all times, and I checked with legal on that. We don't need to include that. That is assumed that these developers and projects need to always comply with federal and state laws. So with that, I would be at alternative 1, including all of these conditions and the modification to 6F as proposed by Springfield Solar and as we've done in other dockets.
I agree. I understand, what the Village of Elmira is suggesting, but it's unnecessary.
Yeah.
So I'm at the same spot.
Yep. And I agree with both for all the same reasons with the modified alternative as suggested by Springfield.
Okay, so 7A is uncontested. It's related to stray voltage testing at 1/2 mile, and that will be approved. 7B is noise studies. We've always done that, and we'll do that. Number 7C is related to constructing, maintaining, and operating in compliance with the National Electric Code and the National Electric Safety Code, and the more stringent of whichever. That is uncontested as well. That brings us to condition 7D. Are the following visual impact mitigation conditions reasonable to impose? Relate to the applicant working with the Village of Elmira and Village of Brownsville to create visual buffers and screening. And the other option is shall work with landowners adjacent to solar panel arrays on one or more sides to create visual buffers and screening in order to mitigate visual impacts as feasible. This is another one where I've wanted to have a light touch and not, order these specific things. Especially in this case, we have joint development agreements with the county and the town. So I did not see the need to order that they do this, but I do think the developer has stated that they will be working in good faith, and that's, I guess, the direction that I would take, is that the developer needs to continue to work in good faith and offer these where the local residents are requesting them. And I would be at alternative 3.
So I was actually at alt 2, and I was gonna require them both, and I was going to take the developers' suggested change to the extent reasonable and economically feasible. The developer did not inspire a lot of confidence in me. So I guess if they're saying that they'll work on it in good faith, but I wasn't very impressed. And so I did think that it was necessary. So I'm actually at alt 2, and I would accept the modification as proposed by the developer.
Yeah, I'm where Commissioner Habener is at because of the JDAs, and they do this, and eventually this is going to be sold to a more local utility if things go through and prove that. But Didn't see anything in here to say that they wouldn't do this or would not. I thought it was a bit overkill to add these, so I'm at alternate 3.
Okay.
Okay. Condition 7E is related to reducing impacts for ground nesting animal species as a condition of approval of the project. This is related to a vegetation management plan and vegetation clearing out and mowing outside of a certain time frame. On this one, my understanding from talking to staff was that their intention and the language provided by Springfield Solar is, although worded differently, the intent is the same, and that staff did not have an issue with the particular language that was proffered by Springfield Solar, particularly to engage a qualified avian biologist to do walking surveys if they do need to mow in the period between May 15th and August 1st. So I was fine with the the alternative 2 as written by Springfield Solar, and as again, staff has said that they are acceptable with that.
Right. I was in the same spot, and I think it's important to point out that the way staff has it written is perfectly fine, but if the developer needs more comfort in their modification, that's okay, but I wouldn't want it to be a signal to staff that they go back to the drawing board and rewrite all of these. But again, it's not unreasonable to accept the developer's proposed modification. So I was at alt 2 as modified by the proposed or by the developer.
Yeah, I think I'm fine with their modified language. I guess just more overall, and this is not specific to this developer, but especially when we see these site and acquire typical things, doing these extra steps, doing these extra costs, maybe protecting something that might be there, might not be there. We don't look at cost now, but eventually this is going to be borne by the ratepayer. So I think just more in the future, I'll be taking a closer look at what are they really agreeing to, and is it just to keep things moving along, because these do add up. Mm-hmm. And is it 100% necessary, or is it based on, well, it might happen? And I think we've just, like you said, got to be a little more judicious in how we need to approach some of these things in the conditions, because we too are learning as we go ahead. Mm-hmm. So I join you.
Okay.
Okay, so that brings us to 7F, and that's related to mitigating impacts to tree-dwelling animal species as conditioned by the project. There's 3 bullets here. The applicant supports, and staff supports all 3. The applicant supports the first and the third, and again, has a slight rewording of the second bullet, and that's related to bringing in the 660-foot boundary, which is the guideline from the U.S. Fish and Wildlife Service, as I understand it. So again, I guess I'm fine with either staff language or the applicant's language, but staff assured me that they were fine with the applicant's language as well. So I was at alternative 2.
Yep, I agree. And I asked staff the same question, and they said they're saying the same thing.
Well, yeah, they are, but basically what the applicant's saying is, like, let's survey first before we have to go out and, comply with it. To me, their language is a lot more logical. Mm-hmm. Makes sense.
Yeah.
So there was anecdotal evidence about bald eagle, but let's do a more formal survey and investigation, and then figure out if they have to apply. That's what they're saying, and I think that makes a lot of sense. So I'm fine with their modified language.
Okay. Issue 7G is related to an independent environmental monitor for the purposes of stormwater and erosion control inspections and reporting for this project. The DNR witness, I think it was, Ms. Minzer, she essentially reported that, there's a lot of these solar projects, and the DNR has a certain staffing level that's able to perform their duties related to the permits, and feeling like they don't have the staff necessary to do that. And so her solution that was proffered here was to have an independent environmental monitor hired. So I do appreciate her a recommendation, and I guess I would like to hear from my colleagues on this one before I ultimately make a decision. I think it's a new idea, so I didn't know if you had thoughts on it before we go to the alternative. Chair?
I have strong feelings. I don't think it's necessary. I get it. Everybody's short-staffed. Guess what? We are too.
Mm-hmm.
In every area of our agency. And so while I'm sympathetic, I think for me, the purpose of an independent environmental monitor is exactly the types of cases, the really large projects that they've been used in the past. Those I can understand. But again, it goes to cost. Who's going to bear the cost of paying for the independent environmental monitor? I don't think that's part of what we should be implementing. So for this one, I felt pretty strongly that it's not necessary. So I was at Alt 3.
Yeah, this was not a close call for me at all either. This is a no, and one for the same. I thought the testimony from the DNR witness was very thin. She basically said, based on generic observations, she didn't give specifics about other cases where they've had issues. That's, to me, that was a thin thing to lie on. And then we're short-staffed. That does not carry any weight. And then the other part was, this developer found an area where they didn't need a Chapter 30 permit. They didn't need a wastewater permit. And now how do they propose to reward them? By trying to be judicious? They want to slap an environmental monitor on them? Yeah. I don't think that's really the wrong message. Mm-hmm. So, yeah, I am at a no.
Thanks on that. So I'll join you both at alternative 3 and just reiterate, I know either from staff, and I think there was some in the record indicating some of maybe the first or second solar farms had some issues. So these best management practices matter. We've had to discuss this in the past, and now it's in our standard one, a pre-construction meeting, so that our staff and DNR staff can point out and make sure that the actual construction company is on the same page with where the risks are going to be and where stormwater management needs to be employed. So I think those methods will be helpful, and those are things we've added along the way as we've done more of these dockets to improve this situation. I'll join you at alternative 3. Okay, 7H. This is related to potential ORIC conditions addressing the potential impacts to natural gas pipelines, as we discussed earlier. The staff put forth, again, 3 different potential conditions, 3 bullet points related to this: complying with the one-call law and making sure that there's a representative from the pipeline present when excavating within 25 feet of the pipeline. Working with the pipeline operators before, during, and after construction to investigate potential electrical interference risk to the pipelines from the project, such as stray current, and then reimbursing pipeline operators for surveys or upgrades related to mitigating those. And the third was ensuring above-ground facilities such as fencing and arrays are not built on pipeline right-of-way. The applicant supported the first and the third bullet, but thought that the second bullet would be overreach. I support the first and the third bullet too. As far as the second bullet goes, my thought was to essentially include the first half and strike the second half. And so what I would include would be the applicant shall work with the pipeline operators before, during, and after construction to investigate potential electrical interference risk to the pipelines from the project, such as stray currents, and then leave it at that. So not imposing the reimbursement. I would be open to that if either of you two are. So with that, I'll pass it to you, Chair.
I was going to be at just the first and the third bulleted conditions. I think we know that there's a utility that's eventually going to apply to own and operate the facility, and they've got a whole bunch of really intelligent electrical engineers. And I think as part of their due diligence, if this were a concern that they likely wouldn't be willing to purchase the facility. So I did think that the second bulleted condition went too far.
Okay.
But I was okay with 1 and 3.
Okay.
Yeah, I agree that, the applicant said the second bullet point went too far. I agree with that, particularly on what should be included in a contract they have with a third party. I think that's a dangerous thing for us to start to impose here, since, we can't, our jurisdiction doesn't extend to that third party. So they can try to put it in a contract. I just don't think we should start to try to put those things in order points at all. And they said that's kind of standard. They take care of that in the contract. We don't need to get involved in that. Regarding your suggestion to basically just keep the first half of that, I guess to me it's duplicative of the first bullet point. I was even like, why do we have to say they have to comply with one call? Of course they do. I would strike that. Of course, I mean, we're not saying they don't have to. They have to. That's duplicative as well. So I would just leave out all of the second bullet point, because that's what the law is.
Yep.
We don't have to restate it.
And I'll join you both there. I'll join you both there. The other thing that I did talk with our staff yesterday about was that responsibility, and it is the pipeline owner's responsibility to ensure the integrity of their pipeline.
Right.
They have monitoring, and he suggests in his testimony some sort of upgraded monitoring that they may need to impose to ensure more real-time operation. So that's really on Guardian to ensure the integrity of their pipeline. So I will join you there with the first and third bullets, 7H. And that we're now through all the individual conditions. Issue 8 is, has the commission complied with the Wisconsin Environmental Policy Act pursuant to with Stats 1.11 and Chapter 4? This is uncontested. There's some testimony about the environmental benefits that was added as well. B is not uncontested. B is, will the proposed project have undue adverse impact on other environmental values? I'm at alternative 1. I think that, first off, the staff's environmental assessment, as usual, was very good. And as you pointed out earlier, Commissioner Nowak, this is a particular site that doesn't need numerous DNR permits that we've had other ones that did need those. So there appears to be less risk environmentally than even previous ones we've seen. So I'm at alternative 1.
I agree. I'm also at alt 1.
I agree with that.
And our last issue then is including should the commission grant a CPCN for the project. And as we've discussed today, I would be at alternative 2 with the conditions that we described.
I agree.
Sure.
I agree.
Okay.
Clean up.
Thank you.
All right, then I'll move in docket 9807 that we approve the application of Springfield Solar Farm LLC for a CPCN.
Second.
All in favor?
Aye.
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 Okay, that concludes our official business for today. Our next open meeting is scheduled for Thursday, September 16th, 2021 at 10:30 a.m. And we have a motion to adjourn.
Move we stand adjourned until September 16th.
Second.
All in favor?
Aye.
Aye.